Okay, so you've seen the video of the attorney freakout in Judge Simpson's courtroom from a couple days ago. I think it was on every channel. But what you don't know is the backstory. And it's a deep one. Are you ready?
Breaking news, tragedy unfolding in Superior Township where two teenagers have been killed in a rollover crash. Another person in that car was rushed to the hospital and now in critical condition.
This all happened this afternoon on Superior Road near Huron River Drive, and deputies say speed was indeed a factor.
It was an absolutely horrific crash. And there were two teenage girls in the car that were cousins, and a sister to one of the girls was critically injured and taken to the hospital. The two cousins didn't make it. There was a lot of confusion initially about what exactly happened. The information came from the person that was in the other car that they supposedly had a minor accident with.
A rollover crash in Superior Township kills two teenage girls and sends a third to the hospital in critical condition. Topping our news on this late edition tonight, that accident shutting down Superior Road between Huron River Drive and Getty's for hours.
Mara McDonald is at the Washtenaw County Sheriff's Office tonight. Mara, police believe the teens were involved in a hit and run prior to losing control of their truck.
Kimberly Devon, yes, that's what the preliminary information from the Sheriff's Department suggests, that the girls in this truck hit another car and didn't stop. The wreck took hours to investigate and finally clear. What's left of what the three teens were driving appears to be a pickup truck. Police say they know speed was a factor, but they also wonder whether these railroad tracks are what caused them to lose control.
The accident took over a year to investigate. They did accident reconstruction. They had experts, the whole 9 yards. 1 year and 24 days after the accident, which occurred on August 2nd, 2021, an arrest warrant was issued for John Torres, who was the driver of the car that the girls apparently got into a fender bender with. August 26th, 2022, the warrant was issued by Magistrate Mark Nelson for 2 counts of reckless driving causing death. He was arraigned September 2nd, 2022 in front of Magistrate Fink and received a $5,000 bond. Following that, there were 9 probable cause conferences. This led us up to March of 2023. Mr. Torres had hired Brian T. Dailey's law firm to represent him. Mr. Dailey's associate filled in on the March 9th, 2023 PCC held via Zoom. Unfortunately, I don't have any of those. Apparently, sometime before or during that hearing, Mr. Dailey's associate agreed to a plea deal on behalf of Mr. Torres, where he would agree to a reckless driving charge, taking off the causing death, which reduced the severity of the charge. This brings us to the April 13th, 2023 hearing. This one I do have.
Court calls the case, People versus John Torres.
John Armstrong, Assistant Prosecutor on behalf of the people.
Hold on.
Attorney Dailey emailed Ms. Tang. He's having a hard time getting in. It's not correct.
It's at Mr. Torres' case. Okay. All right. Mr. Torres,
Yes. Hello.
we got an email from your counsel, Mr. Dailey, that he's having some problems logging in, but he's trying to get himself in. So I'm going to pass your matter for a moment, and hopefully he'll be with us soon, okay?
Okay, I just sent him a message and the ID number, so hopefully he gets it.
Yeah, I hope so too,
Okay.
but we'll wait and see. All righty, thank you.
I appreciate it. Thanks.
Good afternoon,
You're
Your
welcome.
Honor. Sorry for the trouble.
Okay, court does call the case of the People versus John Torres.
John Armstrong on behalf of the people.
Brian Dailey appearing on behalf of Mr. Torres.
All right, we had passed it. I'm glad to see you made it in, sir.
Thank you very much.
All right, we, okay, I see what we got. All right, I have a plea form. Is that what we're doing today?
Your Honor, if it's a plea to a reckless,
It's a plea to reckless driving and plea to add count 3. Okay, yes, plea to the count 3 reckless driving. And upon that plea, counts 1 and 2 would be dismissed. There is no sentence agreed.
right. I can't agree to a reckless. If one of my staff members already did, then I'll stick by that, assuming that Mr. Torres has agreed with that, but I just spoke to him today and he is not willing to do a reckless. We don't think he did anything wrong in this case, Judge.
All right.
I spoke to Ms. Kirby, who stated that Mr. Dailey did agree to the reckless. There was a note in the file stating he agreed to the reckless. I sent the plea form to him for his review and he said, if that's what we agreed to, I thought it was a careless, but if that's what we agreed to, then okay.
I think if I may correct you, I didn't go to the last hearing. The last hearing was attended, I think, by my associate, Luke Geringer, and I have not been able to follow up with him to find out. But I can tell you right now, I never agreed to a reckless ever, and I never would.
Oh, I see. I have a note from Kirby. She updated it. She said Luke agreed to the reckless.
Okay, and I had to check with Luke to see if that's true, whether or not he had authority from my client, because my understanding is that Mr. Torres does not want a reckless. He'll take a careless, but not a reckless.
Okay, well, I'm not going to be part of these negotiations, but here's what I'm going to do so that we'll just do this. I'll just set this for a preliminary examination. We're either one place or the other. You guys can try to resolve it.
Thank you.
That'll be set for, no, I'm going to go, it's us. April 25th, 2023, 9 a.m. That's before me.
Now, that shouldn't have been a big deal. They just go back, renegotiate, figure something out. But right about that same time, the ish hit the fan for Mr. Dailey. Apparently, his law firm filed for bankruptcy amid an embezzlement claim. There was some kind of insurance dispute. It was way too complicated for me to try to dig into. It is all over the place. He had a radio show and he actually gave advice, legal advice on this radio show. And something happened and he filed for bankruptcy. He did not comply with the court orders in the bankruptcy, which included turning over records and something to do with a 13-year-old Cadillac. Okay. Then, even worse than that was the charges in Illinois. He was charged with conversion. He was depositing checks that were intended for clients in his IOLTA account, and then the money was being withdrawn and used for personal gain. It totaled over $730,000, I believe, and the charges against him and his license in Illinois are pending. I believe there's also complaints against him in Michigan, and there's several lawsuits against him in addition to the bankruptcy proceedings that are going on. Needless to say, I don't think he continued to represent Mr. Torres. It appears that reckless driving plea deal was ultimately rejected, and about 2.5 months later, a preliminary examination was scheduled.
That's called the case. The People versus John Torres.
Good morning, Your Honor. Joshua Van Laan on behalf of Mr. Torres, President Court, sitting to my right.
All right, very good. What are we doing?
Your Honor, today's the date and time set for preliminary examination. At this time, the people are asking for the court to remand on an added count 3 of reckless driving 257.626, which is a 93-day and possible $500 fine.
Any response to that, sir?
Well, Your Honor, we're still in district court, so I don't think there's any remand that needs to be done. I mean, we're here for preliminary examination on 2 felony charges, reckless driving causing death. And now they want to amend it to 1 count of reckless driving. I don't think it's, I mean, they can amend with the court's permission, of course, but this has been going on since June of 2022, Judge. I mean, he's had his vehicle in storage, $13,000 in storage fees. I mean, at this point, I feel like the case should be dismissed. And if they want to reauthorize and re-swear to the warrant on reckless driving, they can do that. But we came here for preliminary examinations today and they can't proceed.
And Your Honor, actually, we can start preliminary examination today. I do have my officer in charge here, but I'm asking for a misdemeanor reckless driving, so I would ask the court.
You want to start the exam?
Well, Judge Simpson, I don't want to go
start
forward
the
with
exam?
felonies, but
I mean, he's got 2 felonies. They're saying they want it remanded down on a 93-day misdemeanor. If you want the exam, we'll have the exam. I'm here all day.
I certainly don't want to go forward with 2 felonies if they're going to dismiss them on their own.
Well, that's what they said, but then you kept talking. So you tell me what you want me to do. I'm ready to go. I'm here.
Judge, I don't oppose the motion to amend. I guess my question is, Judge, can we have the vehicle released with the storage fees waived now that there's no longer a death case?
Have you guys talked? I mean,
No, Your Honor, I actually have not spoken to him. He's not the attorney that I've been speaking with this entire time, but I did tell him this morning what I plan to do. I have spoken to the family at length. I have spoken to the other attorney. He said, I'm of counsel, so I know what's going on and I can handle it. So I have not spoken to him other than that. I have no control over the fees of the car. So, and it will not be released until the trial is finished.
Okay, what do you guys want me to do?
No objection to
I
the
mean,
amendment.
if you want me, if you want the exam, counsel, we'll have it.
No, Judge, I wouldn't do that to this court or my.
No, it's
Nor my
nothing to me. I am here all day. I am here to hear every case that's here. You want your case heard? If your client wants his case heard, we'll hear it.
Well, I certainly wouldn't do that to my client either. So I don't oppose the amendment, Judge. And if there's nothing that they can do about holding the car, I can file a separate motion for that.
Where does this go? Oh, to me. Beautiful. All right. And you're dismissing counts 1 and 2 and adding the cat 3 and it's remanded down. All right. Counts 1 and 2 are dismissed. So it's gonna stay here on the count 3 reckless driving, 93-day offense. Counsel, do you waive reading of that and presentation of a complaint, or do you wish one prepared?
No, Judge, that's okay. I would waive a formal reading and ask that not guilty.
And your client pleads not guilty to that charge?
Yes, thank you.
All right. Pleads not guilty to that count 3. Set a pretrial in this matter for
July 19th.
July 19th, 2023, 9 a.m. That's before me. Oh, joy. Bond continued.
Thank you, Your Honor.
Thank you.
Now, what just happened there was incredibly interesting in my mind. They took the offense down significantly. He was initially charged with 2 counts of reckless driving causing death. That is a felony that carries a penalty of up to 15 years in prison and a fine not less than $2,500, but not more than $10,000. That's a significant charge to be facing. Now, they've reduced that to just a reckless driving charge. Just reckless driving. 1 charge. That 1 charge carries a penalty. Now, this is a misdemeanor charge. They went from a felony to a misdemeanor, and it's punishable by up to 93 days in prison or a fine of up to $500, or possibly both. Or could be probation. Like, it doesn't have to be jail time. If it is jail time, it's only 93 days. That's the max. And you lose your license for 90 days. you get 6 points. So if he has a lot of other traffic tickets, he could lose his license a lot more because, points add up and it takes a while for them to fall off, things like that. Go talk to Judge Norbrick if you need, information on how to get points off your license. But the attorney came out to the gate arguing like, well, they have the right to do that, but yes, that's great. They're reducing the charges. Let me talk to my client. We'll figure something out. Like, don't argue against getting major charges, 15 years in prison, taken off the table, and you're worried about getting a car out of storage? He's not going to need a car when he's in prison for 15 years. Frustrating. Very frustrating. I don't feel like this attorney knows Judge Simpson very well, and I feel like they just got off on the wrong foot, and that probably set the tone for everything that's yet to come, on top of some other things that I'll tell you about later.
Thank you. Court calls the case of the People versus John Torres.
Caitlin Kirby on behalf of the people.
Oh, Your Honor.
To PD.
No, Your Honor, I believe he has private counsel.
Pardon?
I believe he has private counsel.
Did they come into it? I don't.
Yes. And,
Oh, I do see it. Dailey?
oh, is Mr. Dailey here now?
I don't know.
No, it's
Mr. Dailey has not been here. Attorney Van something showed up for him.
yeah, Josh Van Laan. It was here. It was,
He's no longer here.
uh,
All right, if you got a cell phone, I'll pass it so you can call him, sir.
okay. Okay, thank you.
Thank you.
It looks like his attorney waited around a while, then left, and there's still some confusion over Dailey. He must not have filed a withdrawal. I didn't see one. Fun.
Taurus. I've got it. What day do we say?
Yes.
All right. Court does call the case of the People versus John Torres.
Caitlin Kirby on behalf of the people.
And Joshua Van Laan on behalf of Mr. Torres, Judge. Good morning.
All right. Record should reflect they have a bench conference in this case. My understanding is there's a request for a non-jury trial in this.
That's right, Judge. I spoke with Mr. Torres. He's willing to waive his right to a jury trial, and I think we'll be able to proceed a lot quicker and easier that way.
All right. Mr. Torres, is that correct?
Yes.
All right. And you do understand you have an absolute and constitutional right to have the matter tried before a jury.
You have the right to have a jury trial.
Yes.
All right. And you understand that by waiving that, it'd be tried before the court without a jury.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Based upon the statement of counsel and defendant, court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for September 27th, 2023 at 9 a.m. in person. Bond in this matter will. All right. Thank you.
Your Honor. Okay. Yeah, sorry. Right.
This is the part where things get crazy. So you heard him agree to a bench trial that was scheduled for September. That was canceled, and it was rescheduled for October. That was canceled, and it was rescheduled for November. Now, November was that period of time where Washtenaw was doing no Zoom meetings, hearings at all. Nothing was being broadcast. So we didn't see any of the hearings to know exactly what transpired during them. I can tell you from the docket, or the case docket, that the single reckless driving charge was dismissed, and it was replaced with a failure to stop after an accident with property damage. Mr. Torres agreed to plead no contest to this, and a pre-sentence investigation was ordered by the judge. This all happened on November 20th, 2023. Now let's jump back for a second to the time of this hearing. Right around when this hearing happened, there was a comment on the original news story discussing the accident. Now, keep in mind, this is an anonymous comment that we have no factual basis to back this up, but I found it interesting. And what it says was these girls were chased/stalked. And that's the part that WDIV, which I believe that's the television station, will not correct. This was not a hit and run. The driver who passed, meaning the girl in the truck who ultimately crashed, did get out and speak with the man, Torres, who she bumped. They communicated, and he had no damage to his car. He is not a victim and should be behind bars. WDIV needs to follow up this story and report accuracy instead of making these deceased teens look like they deserved it. Who deserves death like this? I know the deceased driver's mother firsthand, and this is disturbing to her. It's disturbing to those in grief that the portrait of their dead loved ones is soiled. Basically, the point I was taking from that is that's a different account of the accident than what was reported at the scene. Now, we don't know what was reported in the accident reconstructionist report, but this is saying that they got out, took care of it, but then he, for some reason, started chasing them, and that's why they were speeding and got into the accident at the railroad tracks. So that's a little interesting. So regardless, now we're going into a hearing. We are all the way to January of 2024, and we are up to the sentencing phase. Because Mr. Torres has pled guilty, the charges were reduced from reckless driving, causing death, 2 counts, 15 years in prison for each count, all the way down to a misdemeanor charge of failure to stop at an accident with property damage. This new charge still carries a penalty of 90 days in jail versus 93, and that's a maximum, not more than 90 days in jail, or a fine of not more than $100 versus $500, but the penalties as far as the traffic, the license suspension and things like that are a little more subjective, I guess. They're very similar. So I'm not really sure the reasoning for changing it. Someone with more knowledge of Michigan law could probably answer that question.
Your name, sir?
My name's John Torres, Your Honor.
Counsel, you want to state your appearance?
Good afternoon, Judge. My name is Joshua Van Laan. I'm standing in for the attorney of record, Mr. Brian Dailey, on behalf of Mr. Torres. Mr. Torres, do I have your permission to do that?
Yes.
Judge, my sincere apologies to this court that nobody showed up earlier. I apologize.
All right. Have, Mr. Torres, have you read the pre-sentence report in this case?
No, I haven't.
Counsel, do you
Judge,
know if, go ahead. I'm
sorry, Judge. It was sent to me. I did talk about it with him, and I talked about the recommendation with him. I didn't send it to him because he was present in your court at the time. And again, I got the call from Ms. Wielding about coming into court. So I wasn't able to send it to him, but I did talk to him about it.
All right. You did discuss it with your attorney.
Oh, there was a notice sent to my attorney from probation officer. And I talked, asked him if he read it. And he read it.
Okay, but did you talk to your attorney about what's contained in the report?
No, I did not.
Okay.
Mr. Torres, the conversation we just had when I got off of Zoom and I spoke with you about what was in the report. Do you remember that?
Yeah, Bailey, I did. Yeah, I'm sorry about that. Yeah, I talked to him about it. Yes.
Okay.
Yeah, I'm sorry. I just couldn't.
So you talked about the pre-sentence report?
Yes.
Okay. It's going to be a bit difficult, counsel, because are there any material deletions, corrections, or additions to the report?
I don't see that there are anything that's factually or any deletions or additions that I need. Just disagree with the content of it. That's all.
All right. Go ahead, Ms. Blair.
Yes, Your Honor. I would just like to indicate to the court that the deceased victims' mothers are present and they would like to address the court prior to sentencing.
All right, very good. Mr. Torres,
Yes.
have a seat. I want him over in the second seat. Very good. Okay, who do I have here?
Good afternoon, Your Honor. I'm Rochelle Wilson from the Prosecuting Attorney's Office, Victim Advocate. I've been asked to read the statement into the record, but I'll let the victims' mothers introduce themselves for the record.
Yes.
I'm Sherry Smith. I'm Patience and Deja's mother.
All right.
And I'm Christy Green, Alexis's mother.
All right, very good.
Well, Thomas Pearson, he's giving Patience and Deja's father.
Okay, all right, very good. All right, go ahead.
Thank you, Judge. Victim impact statement for the loss of Alexis Hinton and Patience Lunn. Coming up with words for this particular statement was considerably more difficult than we imagined it would be. How do you put a metric or a value on life, on 2 or 3 lives? If we're being honest, it feels like they slipped through the fingers of our society, and it's taken us to a dark place. In a perfect world, we would have all the answers. We would know why John Torres was chasing our girls. It would never bring us peace, but we could find a way out of the gloom and the shadows that the unknown tends to cast. It would give us an opportunity to make decisions with all the truths, decide if anger, guilt, acceptance, or perhaps forgiveness was merited. And if all are, in what order? Accidents happen every day, but does he bear responsibility for contributing to what happened on August 2nd, 2021? This is the unfortunate side of perception and how subjective it can be depending on one's viewpoint. The justice system is all about what you can prove, but what happens when the evidence falls short of truths that appear certain? This is what happens. We are in court discussing a case where 2 girls were lost and 1 survivor at the age of 15 who experienced unbelievable trauma, diagnosed with multiple sclerosis at the age of 17, and yet remained alive with a daily reminder of what happened. And we are asking for a mere 60 or 90-day sentence to be upheld for a misdemeanor. If there was an exception to be made to increase that time frame, we would ask the court for it today. Now, we have, as a society, have spoken, and we are vengeful, whether we want to be or not. When terrible things happen to those we love, we inevitably are, regardless of jail time or probation or court-related. We want the guilty to experience suffering in some similar fashion or degree as either the victims or their families have, and continue to endure. Now, ordinarily, we wouldn't wish any suffering on any other human being, but pain and adversity can be catalysts for growth. That being said, the number of days served in jail will never balance the scales of what was lost. Their absence in our world has left a void that cannot simply be filled by any sentence. But as big of an injustice as it was not to have a higher severity of charges, it would have been an even greater insult if the max sentence wasn't applied here. Anyone who has been to the crash site can clearly see that the driveway that was used to turn around, which means the carnage of the wreck that was witnessed before the 911 call. While we typically reserve this word for positivity, we hope that those visual images visit the one responsible daily, just as memories visit us. That the regret of one's actions settle into the soul of the guilty and eats away at their conscience. One can only hope that one day, whether it's tomorrow or 10 years from now, that there will be some level of culpability and contrition here. While we can't promise it will be met with understanding and forgiveness, it would reinforce our faith in humanity. Alexis Haley Hinton, Patience Nicole Lunn, Deja Marie Thomas. In all of this, their names need not be lost when the record is final. Regardless of what transpires today, they are why we are here. Alexis Haley Hinton, Patience Nicole Lunn, and Deja Marie Thomas. Thank you, Judge.
Come up to the stand. Counsel, is there anything you or your client want to say before I do impose sentence?
Yes, if you don't mind, Judge, thank you. And first off, it's not lost on me the fact that there are families there that lost their children. And I've been to your court a couple of times about this case, and the families have been there, and they've been respectful to me, and they've been respectful to Mr. Torres. So I want to make sure I make that clear. And I mean no disrespect in the way that I advocate for my client. I know you know me, Judge, and I know you know that, but I want to make sure they understand that. This is a case where the prosecution themselves dropped the charges on the reckless driving causing death. My client pled to a failing to stop at a property damage accident. And I don't know how else to say this. I don't want it to sound, you know, like there's no empathy in it whatsoever, but there's not a victim to the failing to stop at a property damage accident. You know, the evidence is what it is about what happened that day, and it is sad what happened. It really is. But he's not here because of a reckless driving causing death. He's here because he failed to stop at a property damage accident. And Judge, I'd ask that you sentence him for that. I mean, to ask for jail time, even the recommendation from probation, it just seems, I mean, that we're linking two things that aren't linked. I mean, this is not, Mr. Torres never would have entered a plea to something that put him at fault for this accident or responsible for this accident. This isn't the accident we're talking about. The accident that he failed to stop for is the rear end collision that happened when he was struck from behind with the truck. It wasn't failing to stop for the accident that resulted in these girls' death. It wasn't that at all. The plea was based on the accident that happened before that. And so, again, I can't state enough that you know, it was painful to read the police report and to see what happened as well for me, and I feel bad for the families. But Mr. Torres isn't here being sentenced for that, Judge. So I would ask that you sentence him to fines and costs, as you would with a failing to stop in a PD accident.
But counsel, let me just, I understand, I guess, the argument that you make, but as I understand factually here, there's a rear end collision, and whatever the circumstances that transpire in that sort of brief moment, there is then the vehicle that the victims are driving that goes past Mr. Torres. And then there is, as I understand it, there's sort of this high-speed thing that happens. I guess I say that because it seems to me, and one of the concerns that I have with it, and while it may not, I guess, legally fit within the definition of reckless driving causing death, that but for those young ladies feeling that they were chased, the rest of it doesn't happen. Right? I mean, am I missing something here? Because that's the way that I see it, that had, just by way of example, had the rear end collision occurred, Mr. Torres remained where he is, regardless of what the young ladies did, and they leave. If he doesn't go after them, we don't have the rest of it.
And Judge, respectfully, I disagree. I believe that's the facts that the prosecution, you know, want that they have in their police report. I don't believe that's the facts that the evidence shows. The evidence shows that after they took off at a high rate of speed on their own without him following them. Then he took off, and only evidence they have after that is that somebody says from a camera, it appears that he's also traveling at a high rate of speed. But the evidence also shows that none of the vehicles that saw that truck going down the road where it ultimately crashed, none of them saw Mr. Torres's vehicle on that road. He said he turned around on that road, but that was when he lost sight of that vehicle. We have an allegation that that he was following them at a high rate of speed, and that's it. But that's after this accident happened, Judge. I mean, that what he pled to was to leaving the scene of the rear end collision. And I don't want to put the blame on anybody in this situation, especially it's such a horrible situation. But I don't think we need to put the blame on anybody for that, Judge, because we're not here to talk about. We're not here to deal with that situation. And I don't think Mr. Torres's actions after the fact did cause or are responsible for that accident. And if they were, I think the prosecution would have at least attempted to prove it. And I don't mean anything negative towards the prosecutor the way I say it that way. Sometimes when I say things, they come out very, very harsh, and I don't mean that to be that way. I think what we have here is exactly what it is, Judge, an accident. It's an accident. Mr. Torres didn't have any blood, any alcohol or drugs in his system that day. And it wasn't, it was a rear end collision. And I think that they didn't want the cops called on them. And so they took off, and he followed them until he couldn't see him anymore. I don't think that is something that warrants jail.
But counsel, I don't mean to quibble, but certainly in terms of how the court views this, that what I hear you saying, which is different from my impression in reading through the report and everything that I see here, is that the actions, that your client's actions did not cause in any way the victims in this case to do anything. Even if it was, let's say they took off at a high rate of speed, that they continued at that high rate of speed because he was behind them. I mean, what I'm hearing you saying is the fact that your client was there had nothing to do whatsoever with what ultimately occurred.
I don't think that would be an intelligent thing for me to say. You're right, Judge. What I'm saying is I don't think that the fact that my client decided to follow them after they left the scene doesn't result in them getting in the accident that they got into. The accident, by all accounts, by everybody who saw it, the accident happened when Mr. Torres had already turned around. He was gone already. I mean, it's not that the accident happened because he was chasing them. It's because the accident happened on their own. And
I want it clear as I read it that the car with the young ladies continued to proceed because in the manner it did, because he was behind them. Now, granted that the accident that ultimately occurs may have occurred at a later point, I think it's something different though. I mean, for me, I want to make sure I have it right, but that's when I look at the report, that's what I see.
And Judge, with all due respect, I don't believe that the report to be evidence in a situation. That was a disputed fact. That's why it was reduced or taken. That's why the reckless driving causing deaths were taken back, is because they couldn't be proven. There is absolutely nothing in the police report about Mr. Torres. Anything that goes beyond Mr. Torres simply following them and then losing sight of them. Anything else is a disputed fact. We would have disputed. We would have taken that to trial. I mean, we ultimately pled because the charge was brought down to reckless driving, and we worked out the agreement to the failure to stop at the PD accident. At no point was this plea ever based upon any actions that were taken after the fact. But even if it were, Judge, those are disputed facts. The fact that they put it in a police report, with all due respect, doesn't make it true. And the fact that the person who wrote the PSI took that information from the police report doesn't make it true. There was a very good argument, very, very strong defense that the things that were in that police report actually were not what happened, based off eyewitnesses who saw the truck on the road before it crashed, based on eyewitnesses who saw Mr. Torres, not on that road at all. And so I dispute those facts. And again, I'm not trying to make something that might appear to be non-complicated complicated, but those facts are one-sided and they are not the facts that I believe should be in this record. And I don't think we've made a record of those facts. The only record that we have agreed upon in the record that we made is that he didn't stop for the accident and he had to return to the scene of the original accident when he called 911. So, and Judge, again, go ahead.
So,
I'm sorry, Judge.
I understand that there might be disputed facts, but in order for me to properly sentence, I have to, in my head at least, have some resolution of the facts as they've occurred, or at least how I perceive that they occurred. Otherwise, I just sentence on a charge and forget the rest of it. There are certainly going to be failure to stop and reports that are, an accident that the cars bump each other and one person just leaves, or it's an accident and the person just doesn't report it, they go home. You have those cases, I get it. But this one is very different in terms of what transpired. And what is different in my mind about it is the failure to remain, the failure of Mr. Torres to remain where he was. What then happened?
I don't believe that. Oh, I'm sorry,
Go
Judge.
ahead.
I thought you were asking. I apologize. I did not mean to interrupt.
No, go ahead. Go ahead.
I think, and you may disagree with my answer, but the answer to that is what was going to happen because our version of the facts, what we believed to be what happened is, and I'm trying to walk very fine line here so that I'm not trying to dig into anybody, but the reason that the girls wanted to leave the initial traffic stop is because they didn't want to have the police come, because there were some, they're kids, they were doing some things that kids do, and they didn't want that to be the issue. So when they left the scene at a high rate of speed, the initial accident, they were going to continue to do that because they didn't want to have to go back to that accident scene. Now, that's the nicest way that I can say it. I'm not trying to be rude or to anybody, to the family there, but
No,
they left the scene because they didn't want to stop.
I get it, counsel, but the problem I'm having here is you're telling me when I read the report, when I read the rendition of what transpired, I shouldn't take into account things that I see here that give me a bit of pause. Because on the one hand, what you're telling me is that the accident would have happened, or that the rear end collision occurs, these young ladies take off, and that if Mr. Torres does nothing, that this would have occurred. What I read, so that what I just stated is on the one hand. What I read and what I'm seeing is the bump in the rear occurs, and then these young ladies take off, but continue doing what they're doing because Mr. Torres is behind them.
But there's nothing illegal about that.
Otherwise, counsel, And even in terms of just the charge, why? The charge really is that he didn't just stay where he was and report it.
That's what the charge is. Yes. Yes. The prosecution didn't bring another charge based on the following them. I mean, they withdrew that charge. And there's nothing illegal about following somebody that hit you, to see where you're going, as long as you're not, hitting them and assaulting them. I get that they were probably worried.
All right, I hear what you're saying, but I don't see that here. I'm just going to let you know, that's not what I see.
Can I say something?
Your client wants to speak. Do you have an issue with that, counsel?
Yeah, no, don't say anything at the moment, please. Judge, I think part of the reason that you don't see that there is because you're getting one version of the facts when you look at the police report. The police report doesn't have another version of the facts. Mr. Torres wasn't required to give a version of the facts or to say anything. And there's no other independent evidence. Even the video that they said showed him going at a high rate of speed, that video didn't show anything. There's no speed limit out there whatsoever. It's impossible to tell. But had this been a sentencing about somebody being involved in causing the death of someone else, that would be what the charge is. And I see your difficulty, Judge. It's tough because this is a sad situation, but that's not what he pled to. And had he known that this was going to be a situation where he has to, answer for, why things ended up the way they did, instead of just focusing on the leaving the scene of a property damage accident, he wouldn't have made that plea. I mean, it's a difficult case, and I know the prosecution had some difficulty, taking those charges away, and I'm glad they did, because it just wasn't something that could be proven. But if somebody rear ends you and then they take off and you follow them, there's nothing illegal about that. And if those people choose to run away at a high rate of speed and get in an accident, that shouldn't be the person's fault who chose to follow them. And that person shouldn't have to go to jail because they chose to follow them. I'm sorry, it is an incredibly difficult situation. It's very painful. It hurt my heart to read the police report also. It really did. And I know people may never see that, but it did, because it's a sad situation. But the solution isn't to throw somebody in jail because they chose to follow somebody. There's just no evidence that he was, trying to strike them, or that he hit them, or that he pursued them all the way until the accident. In fact, the evidence is the contrary. It's that they sped away from him, and that he couldn't even see them when he turned his vehicle around. The accident hadn't even happened.
And under your version of this, how far did he follow them?
According to the reports, he turned around on the street well before the railroad tracks, and the oncoming vehicles that passed the truck before it was in the accident did not see Mr. Torres's vehicle on that road. So he turned around before that even, at one of the turnarounds as soon as you get onto that road. According to Mr. Torres, what he said in the report was that he lost sight of them, turned around and called 911, and that's what he told 911. So, and that went along with all of the other vehicles that were coming down the road, was that they didn't even see Mr. Torres pursuing that truck. Nobody saw Mr. Torres recklessly pursuing the truck. Nobody. The only thing that saw is a camera and Mr. Torres's own comment to 911 that he followed them.
Okay, I understand that as you're talking about the idea of recklessness, and I've purposely been avoiding that because of what the charge was and what it's been reduced to. What I'm talking about is something a little bit different. I'm talking about young ladies take off. What happens if he indeed stays where he is? Your version of it, right, we may never know, but Your version is the same thing happens. As
My
I
version is
look
the
at
same thing could
this,
happen.
pardon?
So sorry. I'm sorry, Judge. You're correct. My version is the same thing could have happened. Yes.
And when I read through everything, I'm saying, and I'm not trying to attribute necessarily a level of cause, but that that something different happened because he continued after that.
I think in
So
order to
just so that I can finish that point, that makes this a different kind of failure to stop case in my mind. Because if he had stayed, as I read everything, I don't know that the same thing happened.
But I don't think we know that the same thing doesn't happen, though. And that's the thing, is the failure to stop at a property damage accident isn't because they're worried that you're going to take off and chase somebody and have that person get in an accident. It's because they want you to stay behind and to report the fact that there was property damage and that there was an accident. I think what we're doing is we're taking it and we're moving forward with facts that absolutely 100% would have been disputed at preliminary exam and at trial had we known that they were going to be facts that would be considered. And that being the case, Judge, I would have preferred, if these facts were going to be considered, I would have preferred to have an evidentiary hearing on it, or a contested hearing. And that's actually what we initially elected to do before they dismissed the charges. So now those same facts that I initially wanted to contest are being used against Mr. Torres and accepted as true. And I'm not saying you shouldn't be able to do that as the judge. Obviously, you're the decision maker, but that's why we didn't move forward with a plea to anything or with a hearing as to anything, because when we set the case for a hearing on those disputed facts, the prosecution then removed those charges. So everything after this failure to stop at the PD accident, which was a compromise. I suggested that to the prosecutor, who graciously considered it. Everything after that, that's what's in dispute. In my position, judges, it's certainly not fair to consider the evidence as against my client simply for the fact that he chose to plead to something. These are contested facts, and if we're going to have contested facts, respectfully, Judge, I'd ask for an evidentiary hearing on them, or I'd ask that Mr. Torres be allowed to withdraw his plea if we're not allowed to at least contest the facts or put on, to challenge the evidence that the court's relying upon. And I don't think that you're relying upon crazy evidence, Judge. I think you're reading it the same way any reasonable person could read it. But there's also, it could just easily go the other way. And I don't want Mr. Torres to be put in jail for something that, with a proper hearing and proper evidentiary hearing, is something that I don't believe can be proven. And I think the prosecutor doesn't think it could be proven either, because they're the ones who withdrew that plea or that charge.
Okay, I hear you, but I don't know why, and I don't know that it's up to me to try to figure out why charges get reduced, because there are various reasons why that happens. So I don't know. I don't know what was going through the party's mind. I am telling you how I see this case, but I might see it differently. And so right now and you can appreciate this, I'm reading the reports, I'm looking at that, I'm drawing my conclusions from it. I'm hearing you where there's a different conclusion, and because they're typically not at our sentencing, I'm not hearing from the prosecution regarding their side. And then if I hear that, then certainly I can because it's what I do, I can try to resolve that in my head to see if it makes a difference. I think I'm going to need to start out with, I'm going to need a prosecutor present. And if it appears that I'm reading it wrong, I'm reading it wrong, but I'm seeing it a particular way right at this moment. But I'm going to need a prosecutor present. I will leave that to you to make the decision as to whether or not you wish to withdraw the plea and send this back up on either the felony charges or something else. But I can't. I mean, my intent was to follow the recommendation of probation at least. And I hear what you're saying, that if that's what the court's going to do, you want an opportunity to maybe do something different.
So my main concern, the concern was more about the jail. I've talked to Mr. Torres. I'm sure that he doesn't want probation, but sometimes you get probation with a misdemeanor. So I wasn't concerned about the probation, and I could talk to Mr. Torres about whether he wants to withdraw the plea. And I appreciate the court considering my position as well. I just don't want it to be. I've spoken too much on this, and I'm so sorry to take the court's time. But
no, that's fine. I realize that the mothers and I'm presuming other family members are here. So folks, I hope there's an understanding as to what the court is saying, and what I'm about to do. I'm not doing it to cause any more distress or angst on behalf of you folks, as well as I'm not trying to do that in terms of Mr. Torres. I just have to, in my head, be clear in terms of what I'm doing. And none of this is easy, but I hope you can at least appreciate that. And that because this is a hard case. I'm going to suggest, counsel, that maybe you speak with the prosecutor's office so that maybe there can be some understanding that the court could have. I'm going to adjourn the sentencing, and if you can't, then at least you understand where my head is, at least at this given moment. Then you could maybe file your motion to withdraw the plea or do whatever. I mean, I give everybody the opportunity. I will adjourn this to January 24th, 2024 at 9 a.m. Folks, I said everything at 9, but it's set in a different block and time block, and I'm sure somebody will get to you to let you know where that is. Okay. Any questions?
I personally will be present on that day so that I don't have to rely on somebody else to not show up. And I'm very sorry to your court and to the victims' families for having to wait around.
That's fine. Can we, to the victim's advocate, I guess I'm going to put you on the spot. We can make sure that we have a prosecutor here on that date.
Judge, I can do my best to make that request. It may be a little stronger coming from you.
So you want?
Is there a way for you to request that?
I think the email will go out right now. Okay, who
I think Morgan.
would it be? Morgan? Okay.
Has appeared on, Ms. Reiser has appeared on this case before, so I'm not certain. Maybe if it goes to both
of them. Yeah, okay. Why don't we send it to Ms. Reiser and to Ms. Barroso?
I think Ms. Reiser took over for Kirby.
Pardon?
I think Ms. Reiser took over for Ms. Kirby when she left.
Yes. So why don't we send it to Mr. Ganatra, Reiser, Patricia Reiser, and to Ms. Barroso?
There's a couple things we know about Judge Simpson. He has a huge heart, but he also wants to make sure he knows everything that's going on with the case so that he can make a fair decision. sometimes he makes a sympathetically fair decision, but it's, for the most part, he takes everything into account and he knows what he's doing when he's making the decision. And when he's making a decision that leans one way or another, he's doing it intentionally. And in this case, there's so many unknowns. And if you analyze that, yes, he pled to a lesser charge, but how as a judge do you take that into account when you're sentencing them? Because you're pleading to a lesser charge, do you automatically sentence them to the maximum? Because what they did was worse than that charge because they pled down? I mean, that's a whole, I don't even want to go there. So it seems like he's just trying to get to the bottom of, tell me what actually happened. Because nobody's standing up and saying, okay, this is what happened. Why is there not a prosecutor there at a sentencing? That's bizarre. I hear balls dropping everywhere. Just saying. So now we're back. What is this? Like 2 weeks later for the follow-up hearing. We're January 24th. And Ziggy says hi.
Good morning once again, Judge Joshua Van Laan on behalf of Mr. Torres, who's present in court.
Torres, can you state your name?
John Torres.
All right. I understand a couple of things. First of all, that just call them the moms they're present in the courtroom. I know you addressed the court the last time and we adjourned it out for reasons. Was there anything else either of you want to tell the court? Again, you most certainly can address me again. I want to make sure you get
statement that we wrote was kind of addressing everything for all of us. Sherry, the other mom, they had car trouble, so she's watching it on your YouTube.
Oh, okay. Very good. Very good. All right. So there was nothing else you wanted to indicate. But let me say a couple of things to you so that you kind of understand. And if you want to address the court after I say what I say, then certainly you may. First thing is that court went back and I reviewed the police report and other documentation that was given to me because there were two sort of versions of events which would lead me to different conclusions. One version of the events is that Mr. Torres was nowhere near the accident scene at the time. My position initially on reading the initial reports in this was that, okay, he may not have been, but the cause of the accident was because of what had transpired. Now, part of my initial analysis of that would have been what I understood at the time to be his proximity to the accident. There was some discussion the last time, I don't know if you recall, but there was some discussion the last time regarding that proximity. There was then also a discussion as to, which complicates this matter a bit more, that there are actually two accidents that occurred. There's the initial accident, which was basically the bumping into the rear of the vehicle, the rear end collision, and then the ultimate tragic accident that occurred. That's also part of the complication, okay? The next part of the complication comes in that what the original charges were, what the ultimately pled to, and again, there was certainly advocated by the defense that he should be sentenced in accord with the failure to stop an ID at a property damage accident, as opposed to the other accident. I needed, between the last time that we were here and today, a clarification as to what exactly Mr. Torres pled to. Because again, depending on what he pled to, those lead to two different results. I've had discussions with defense counsel in the prosecutor's office, and my understanding, and counsel can correct me if I'm wrong, that what Mr. Torres pled to was the original fender bender or the rear end collision, and not the ultimate tragedy that occurred in terms of that accident. That further, the reason for that was because of his lack of proximity to the ultimate accident, that the data and other information revealed that he was nowhere near or not at all close to the scene of the accident that occurred. Now, having said all of that, I will let you know that that changes this court's conclusion about sentencing in this matter, and would certainly cause the court to depart from the recommendation that probation, who I think was under the same assumption that I was under, had come to regarding the sentencing in this case. So, having said all of that, I don't know, and I guess, Mr. Torres, if you could have a seat, folks, I realize one of the moms is not here. She's watching on YouTube. If she wanted to sign in and address the court, certainly she may. No, right at the table, right here. I've stated what I've said. Did you have any questions for me? Okay, come, I need you to, it's okay. I figured you might, and so I want to make sure I address the question.
So, one question. Sorry.
Yeah. No, it's okay. Can you state your name first?
Yes, Christy Green.
Thank you. Go ahead.
You're welcome. So when you say like he wasn't, his proximity to the accident, are you talking about the second accident?
I'm talking about the second accident. So,
Okay.
So just so you understand where I'm coming from and what I now see, there's the rear end collision, right? And then after that rear end collision, the first car, which your daughter was in, takes off. That Mr. Torres, as I understand the facts now, goes some distance, but isn't in the area when the accident, the fatality occurs. Which is a whole different impression than what I had initially.
Okay.
Okay, so go ahead with your question. I'm sorry.
Okay, so are you aware that the first accident, it just wasn't a hit and run? That there was actually video footage that my daughter got out and they went back and forth. They spoke.
You want to take your time, please.
And he took a picture of her license
Hold
plate.
on, I'm going to let her come up with you. And we'll get to it.
Thank you.
Go ahead.
So are you aware that it wasn't a hit and run because there's two different police reports, right? So there's Ypsilanti. Ypsilanti had it as a hit and run, but then there was a fatality through Superior Township, right? So
The sheriff's department, right?
So when they investigated, because we had sat down with the the prosecuting attorneys, and we went through this and we actually asked quite a few questions when they were originally dropping the charges from the misdemeanors. But they called us in to sit down and discuss all this a while ago. So at that point, we asked quite a few questions. And it's my understanding that from Eastern, there's video footages that see when my daughter hit him, they stopped. They got out of the vehicle, they went back and forth. The detective had Mr. Torres' phone and verified that there was a picture of the license plate that was taken in his phone prior to him chasing them or following them or whatever it is that we're calling that right now. Are you aware of that?
Well, which part? I'm aware, let me tell you what I am aware of.
Okay.
As at least, again, as I understand it, that there's the initial accident.
Yep.
My understanding is that there was some contact between the parties to that.
Okay.
That it wasn't what I guess what one would describe as a hit and run.
Okay.
Somebody took off,
Yep.
right? And again, so that at least you're clear, and I want to be clear as to how I'm looking at it, that what Mr. Torres ultimately pled to was not what it could be a hit and run, but was not a hit and run. It was basically failure to stop at the scene of a property damage accident, because the law requires that certain things have to occur or the person has to do something
The first
at the
accident.
scene. Right.
Okay. So then you said something about the second accident. So all we're talking about is the first accident, because you said he wasn't in proximity of the second accident, and I don't know how.
That's what the data, that's what I see from the data.
Okay, so the first driveway, if you're to pull on that street, he would very clearly been able to see what happened. So I just want to make sure we're not talking about that, because I don't.
See what happened. Okay.
The second accident?
The second accident?
Yes. He was with it.
Whether or not one could see it or not, he was not in proximity to that accident.
What would you consider proximity?
That he's a distance from that accident.
What just
so what? Well, I can't give you a. I can't lay it out by feet or anything like that, so I can't say that. What my understanding, the facts are, is that he's some distance from when the accident occurs. Now, hold that thought for a moment, okay? Because my initial reading of this was that the cars take off, right?
Mm-hmm.
And that he is indeed following them, but doesn't stop.
Right.
Right. My understanding is he stops at some point and the accident occurs further down. But at the point that happens, he's not, whether you want to call it in pursuit, chasing, following, he's not doing that at that point. That's my understanding now. Now, if you believe that there's something that says something different,
Mm-hmm.
then I certainly want to see it. But that is when I'm now looking at everything, that's what I see.
Okay, I don't believe his vehicle. I think it was too old to have a black box in it that would show where he actually was.
That's the data from the accident reconstructionist says something different than what my impression was. That's what I'm.
Okay, so then maybe I didn't see that, but the driveway that he clearly stated he pulled in, I would say is 10 car lengths, 10 car spaces from where the accident happened. So you can say close proximity, not close proximity. We could all have a different understanding of that. So I disagree with that statement because I think it's based on how we would personally look at it. So I just wanted to clarify that, but I don't know that that's going to make a difference in what we're doing sentencing right now for.
Let me just tell you this, ma'am. And I'm just kind of a straight shooter about things.
I appreciate that.
This whole case troubles me, right?
Yeah.
And sometimes I guess it would be great doing this job if I weren't a human, because then I don't have to deal with things that I have to set aside in my mind.
I understand.
Parent to parent, I'll just say this. After we were here the first time, I could only think about my daughter. And that I would want something to happen. I'm not even sure I'm not even sure what I would want, right?
Yeah.
But that I would. And I had to kind of, people I think that when judges leave the bench, we kind of leave everything behind us and we don't think about things. This one has been with me. I want to say a lot, but I think it's been sitting in the background and on just all my thoughts. But I also realized, in great part, setting that emotion aside, I realized I had to do my job, right? And I also realized that if I could, but I know I can't, that I don't have the power to bring back who you lost. In a lot of ways, sitting here is a helpless feeling, because it really doesn't matter what I do.
That's how I feel. That's how I feel.
I can't make it right. And I know I can't. I realized that being limited in that regard, that all I can do is try to make the correct decision. And while this may sound crass, I don't mean it this way, but it's the best words that I can come up with, and then let that fall where it may. And the way for me to do that is to try to make sure I have a clear understanding of, as best I can, what happened. If, and I said this before, if my impression that I had initially was that there's the rear end collision, and then at some point this chase happens, and I purposely use that word chase happens, then the consequence of that chase may rest with Mr. Torres, right? That's one scenario. The other scenario is the initial accident happens, and then there may be this brief moment, and you're right, they're out of the vehicles at some point. Then there's this brief moment where the vehicle takes off. He may even be headed in the same direction, but then stops, calls the police. Under that scenario,
he wouldn't then be attributable, or it wouldn't be attributable to him, and he wouldn't be the cause of it. When I went back and like I said, I'm just trying to do the right thing. And when I went back and looked at everything, it's that second scenario that I'm seeing. And if you think that there's something else that I should look, I looked at everything, but if you want me to look at something else before I approach sentence, I will do it. I mean, I don't know that it would lead me to anything different. But I will say this, I also didn't think looking at it again would lead me away from the first conclusion I had. Yeah. Right? But if there's something you think that I should look at, I'll do it. I mean, I'm not, like I said, in the end, I can't bring your daughter back. I can't bestow upon you just peace and solace, and I can't do that. But what I can do is at least have you believe that somebody looked at it and looked at everything and that you were heard. That I can do. And if that's what you want me to do, I will do it. When they told me, and I know when we adjourned it out, I was informed by the victim's advocate that you guys were on your way and that you were stuck in traffic or something like that. And my words were, we'll wait. I could have gone ahead because you've already addressed the court, but I said, no, I'm going to wait because I want to make sure that they're heard.
Thank you, and I appreciate that. Can you grab my phone? I want to make sure that Sherry, she's watching. I want to make sure that she doesn't have anything to say. So the question that you're asking about—
You're in communication with her then?
Yes.
Okay.
Yeah, she's watching on Zoom.
Did she want to sign in? I mean,
that's what I'm trying to find out right now.
Okay.
So the question is go
ahead. You can message her if you want.
If I want you to look at additional evidence. We're talking about evidence on just the first leaving the scene of the accident. What is being charged for? Is that what you're asking me?
No, what I'm asking you is that if you think that there's something I'm not seeing that would lead me to change my view of now what I have about causation, I'll look at it. I don't have a problem doing it.
Okay.
And so that's maybe to better answer your question. It's that period between the first accident and the second accident. That time frame.
Okay. I don't know if you want me to step out and make a call or if you want me to do it from right here.
You want to call her to see?
Yeah.
Okay. If you want to step out, you can make a call. Go ahead.
Thank you.
Sort of briefly pass them. Doris, you can remain right there. Yeah, I got you. Thank you, guys. All right.
Sherry did join.
Oh, she joined. Okay. Let's see. Where is she? Is this her? She's a pink square. Oh, got it. I was looking at somebody else. Miss Smith? Oh, there you are. Okay. Can you hear me? Oh, I can't hear you. She's not muted. Is she connected to audio?
She is connected to audio. She is having issues with her mic.
Your microphone.
I can see your lips moving. I can't hear a word you're telling me, ma'am. I'm sorry. You know how to adjust your microphone? Okay, Ms. Smith, try again. Unmute. Let's see if we can hear you.
All right, can I be heard now?
Wow. Okay, remember that. We just learned something today. Okay, Ms. Smith, try again. Unmute. Let's see if we can hear you.
Can I be heard now? I am unmuted.
Yep, I can hear you. Does she have another device?
She had YouTube on.
Oh, you gotta turn YouTube down because otherwise I hear myself twice and I don't even like listening to myself once. So.
All right.
I got it? Okay. All right. Now everybody's here. Okay. Was there did you have a question, ma'am, or something else you want to tell the court? I think you were listening to what I said before.
I would really like for the initial phone report when he called into 911 to be relooked at, because from my understanding in that 911 call, admits to the chase. He admits to turning in the driveway before the railroad tracks, and he admits to seeing some dust. So what dust did you see if they're on a paved road and you're not on a dirt road? The dust you saw was them going over them railroad tracks and crashing.
I thought I had seen a. So what you're asking me, just so that we're clear, you want me to, if it exists still, you want me to listen to that 911 call?
I would love for you to listen to that 911 call. I mean, I know at this point it's probably not really going to change anything that we're looking at, but at least to get our understanding heard and maybe get a different look at it. It's just, if you're admitting to it and you tell them you turned around in the driveway before the railroad tracks, which is where they crashed, none of it just sits well with anybody.
Okay. Ms. Reiser, does that still exist that the court could get a copy of the 911 call?
Yes, I believe so, Your Honor.
Okay. So you want me to listen to the 911?
Yes.
Anything else you want me to?
I mean, I know in the end, it's like I said, probably not going to change anything, but at least we are heard. At least it makes a difference in my eyes that it's heard and it's relooked at.
Okay. I can't, so that you understand, I'm looking at it for the purposes of sentencing from my standpoint. I can't change, I don't have the authority to change any charging decision, what the plea was or anything like that. So I want to make sure you understand that that's not why I want to see all of it. I just want to have the correct perspective on it. And if you think that will lead to something where it may change my thought process, then I don't have a problem looking at that, Ms. Smith.
I definitely do.
Okay.
And the only thing that I just want to add is that he had a picture of the license plate from the first accident. When he left, he already had the information he needed to file a police report on it. So that's the only thing I want to add for it.
Okay, so that's the second time that you mentioned that, and I want to make sure I understand what you're trying to tell me on that. So let's say that this picture exists. I'm not disputing that it does. The picture exists on his phone. What do you want me to
take from that?
So the charge that you're sentencing on right now is leaving the scene of the accident, the first accident, not the second accident, correct?
Correct.
Okay, so leaving the scene of the first accident, I just wanted to clarify and make sure that we all knew that it wasn't a hit and run because Ypsilanti had that in their police report, and then when Superior Township Sheriff's Department, they clarified that it was not a hit and run. There was a stop. My daughter and Mr. Torres got out. They had a conversation. He went to the back of the truck. He took a picture with his phone of the license plate. There was also text messages that were sent from the accident that was sent to someone saying she just ran into somebody, and he's taking a picture of the license plate. So that's what made us ask the question, and it was verified that they took his phone, just like they took the girls. They had all the phones and evidence, and there was a picture, according to Detective Yee, that he did have a picture of a license plate in his phone. So technically, he really didn't need to leave the scene of the accident. That's what I'm adding to it.
That he didn't need to leave the scene.
He
Okay,
had all the information to make a police report, a proper police report.
right, but he didn't. That's part that, so.
Right,
part
so
of-
why did you need to pull off and proceed with the chase when you had all the information?
Well, okay, I hear you, and let's back up a moment, okay? So that you understand. If somebody's involved in an accident, what's really supposed to happen, ideally, is everybody is supposed to remain there and call the police. So what I hear you saying is he could have remained there, but did not.
Mhm.
And had the information that he needed to do the police report.
Correct.
Did I got that?
Yes.
Okay. Right, and I'll probably have to think that through, but I don't know what I would do with that. And the only reason I say that is because I really could say the same for both vehicles.
Well, clearly.
Yeah, that both
Mhm.
should have remained there.
Yes.
Having done this for a while, I can tell you that doesn't happen. Usually one is off someplace or nobody does anything. So I mean, I'll think about it, but I don't know. I don't know really what I would do with that piece, or that I could say.
Can I add something else?
Yes, I just want to, let me just finish this point.
Okay.
I don't know that I could try to sit there and hold Mr. Torres or your daughters to a higher standard than what in practicality happens out there.
Mhm. Yeah, I mean.
But I'll think it through. I mean,
Okay.
Okay.
Also the 911 call, I believe, he said he was following them, chasing, whatever the wordage was used. I did not hear the 911 call. But he stated that he was following them, chasing them, whatever, to get their license plate number. Like that was the reason for
Okay,
it.
I see what
And
you're
here
saying.
you had it.
Okay.
I
So what
think
you're
more
saying
just
is.
pointing that out.
Got it. So what you're saying is the picture was already taken.
Correct.
That's how this flows in. Okay, I see. The picture is already taken, but then at some point in the 911 call, which occurs later, he's claiming that he is following them to get the license plate.
Yeah, because of a hit and run.
Got it.
And
Can
again, I
add
did
one-
not.
Or ask one more thing?
Yeah, certainly. Go ahead, man.
Through this whole court situation, my surviving daughter has not been spoken to, and even got to tell her side of any of the situation. The number one key I feel in the whole situation should have been her being the survivor, and she should have been talked to. Is there a reason that she, as the only surviving witness, has not been brought into this?
Hey, let me just stop you there. And that's the one caution that I'm making. I can't wind everything back.
Mhm.
I can't
I can't do that. I can't make these charges become something different. I can't change the plea. I can't do that. And so the question you asked may be a very good one. I don't know, but I'm not involved in the investigation part of these things. So even if I knew the answer to that, I don't know that it would do me much good, because I can't, that would not be my normal bailiwick to operate in.
Yeah, it's just based off of the current charges right now on the misdemeanor for leaving the scene of an accident. That's what where we're at right now.
Right. And so I can't get into anything in the investigation. I can't really get into that. I mean, I can look at things, but I'm only looking at them for the purpose of making sure that I impose the best and most just sentence I can. I mean, that's all I can do.
Yeah, and I think the reason that she brought up the 911 call is because after leaving the scene of the accident, which is what the charge is right now, right? He didn't necessarily have to leave the scene of the accident because he had the information with him, and the kids didn't either, but they're not here to, you know, be charged or whatever else. So she was saying, just listen to it. Because he says that he is speeding, he's doing all these things. He was going for the license plate number, which he already had in his phone.
I will absolutely do what I say I'll do. And so, Ms. Reiser, how long would that take you to get that to Ann so that I can hear that?
I think I can email it. I can try to do that.
Okay. Okay, if you can get that to us, if it has to be on a drive or something, then we'll just have to do it that way. It doesn't matter to me. I just want to hear it. They want me to do that. Is there anything else you want?
Can we adjourn for you to do that?
Pardon?
Can we adjourn for you to do that? I've had a couple other hearings I need to go to, and
you're breaking up on me, counsel. Yes, I'm going to adjourn the
for you to do
hearing.
that.
Yeah, I will be adjourning it, if that's okay with everybody.
I'm sorry to interrupt.
Well, if it's not, that's what I'm going to do anyway. So I'm going to adjourn it so that can get to me. I'm sorry, your last name again?
Green.
Green?
Yeah.
Yeah, because I can't remember simple names, right? Ms. Smith, Ms. Green, is there anything else you want me to look at, or anything else? And again, I just expressed to both of you, I can only do so much, but I'm willing to do what I can, at least so that you're heard. So if nothing else, and that's not great consolation in the circumstances, but it's all I got. So
are you able to watch the videos that they have from the campus of the actual first initial rear end?
Okay, you want me to watch the videos? Okay, so what would you be asking me to look at regarding that?
Because from my understanding, he also waves them to go around him once they all get back in their vehicles. So if they all get back in their vehicles and he's waving them to go around him, why are you waving them to go around you?
Okay, so let me ask you this. What would you want me to do with that information? Let's assume that that's true. What would you want me to do or draw from that?
So him leaving the scene of an accident, if you're waving them around, you're basically telling them, go ahead and go. So they leave, you leave, and then you proceed to call 911. If you're waving them to go around, that's basically you saying, go, everything is okay. That's like a setup. So basically you set them up. If you're waving them to go around you, you're basically saying everything is okay. So then you call the police after you wave them to go around you.
Okay, but what do you again, assuming what you're telling me is the truth, what would he be
your theory about what he's setting them up for?
We don't know what, that's what, the initial thing is. Why did you waive them to go away and change? I just want you to look at all aspects before you final sentencing on your decision.
Okay, I mean, I'll look at, I went through stuff and, I'm just gonna let you ladies know, I normally don't do this. I get my report, I look at my report, I kind of have my thought process as to what's occurred, and that's what factors into my sentencing, but I'm willing in this instance to go beyond where I would normally go because I want to get it right. Not that I don't want to in other cases, but I want to certainly get it right. It's not going to make everything right for you guys, but like I said, I will look at it. But I again will say, I'm not going to be stressing to the prosecutor, defense counsel, anybody else, or the police that anybody did anything wrong or did any of that, or they should go back and I'm not doing that.
No, we understand that.
Okay. Yeah. I just want to look at it, see what it is, and be able to formulate my decision. And whether you agree with my decision or not, and I tell attorneys this all the time, in some ways I can't be concerned about that, but I just want you to know that I did the best that I can in terms of reaching my decision, that I looked at everything. And that's what I want to look at here. So,
and I appreciate it.
So I will, I'm not clear with regard to looking at that video. I don't know that that video gets me anywhere. I mean, I know that there's the collision. I know there's a contact between the individuals. I know that there is then both vehicles leave. That's what I know. It's really the issue, as I kind of explained from the beginning, what happens from that point when both of them sort of leave, and then the ultimate accident that occurs. That's really kind of where I'm focusing in terms of what I do with this portion of the sentence. So I'm not sure that what you're asking me to look at, I don't know that it will help me in that regard. But if Mr. Reiser, if that's broken apart, I'll look at it. I just don't know that it's going to get me anywhere, but I'll look at it.
You're talking about specifically the cameras from the accident. The first.
Pardon?
You're speaking specifically of from the camera video footage of the first accident.
Of the first accident.
Okay.
That's what I believe Ms. Smith was talking about.
Yes.
So
Okay.
I don't have a problem. I'll look at it.
And we do appreciate you, and we watched you on YouTube for quite some time at the very beginning of this case. So we kind of understand how you work, and
how you understand how I work?
A little bit.
A little bit.
What's that mean, Miss Green?
No, just watching you and giving people opportunities. I mean, I think that you've been very fair in most everything that we've watched. So, and we were hoping that it carried along with you. We weren't changed to different judges at different times.
Well,
so
I appreciate those kind words. I really do. I do. I don't know that I could say much else to that, but that did not fall on deaf ears. Thank you very much for that, man. Okay, so what I will do, Ms. Reiser is going to get those two things to me. My next date will be
February 14th at 9 a.m.
February 14th.
Valentine's Day. Can I don't know if I'm allowed to request, but we tend to have struggles. I'm from the other side of town. So going through rush hour and everything else, coming all the way across.
Town.
Yeah, Clinton Township.
Oh, that's a whole other place. Other side of town is west side of Ann Arbor. No, go ahead. I'm sorry.
So, and then usually we have a group where we got to stop and do ride shares and whatnot.
So okay, so hold on.
10 or after.
Hang on. But, and Ms. Smith, were you going to try to make it too?
I will be at the next one, yes.
Okay, so let's do this. Hang on.
I'm coming from downriver, so I'm coming a nice little distance myself as well.
So you're coming from way, okay, hold on.
Yeah.
Going like this.
No, they want to be here. So just make it, why don't we make it on that date?
Judge,
Okay,
I'm in trial the
so
week of the 14th.
counsel,
Yes, Judge.
will the 14th work for you?
It does not. I'm in trial in Macomb County Circuit Court, Judge Viviano's court for Bowen's trial.
Okay, so hold on, let's find a date that's gonna work. Just give me a special.
Although if the court, Judge, if the court allows me to appear via Zoom, I will make that work.
So you can appear via Zoom that day?
Yes, I'll just make sure I let the judge know that of the trial that I have.
Okay. And I guess out of courtesy, I should ask Ms. Reiser, will you be available? But you will be, I know. I was thinking of giving this a switch, February 14th at noon.
That's perfect for me.
I don't know about you, but I kind of feel like this is what we call a dumpster fire. Like, wow. I don't even know where to go with that. There was so much information and so many questions, and I want to see all that video and read those police reports. OMG, I need more. Give me the information. That was a lot of information, though. Maybe hold off on more for a few minutes. Let me digest this. That went like off the rails really fast. And ugh. So, as you can see, the past hour and a half has been summarizing the past year of what these parties have been going through in this case. And this is what led us up to the explosion that went viral in the LawTube world, where the attorney lost his shit on Judge Simpson. And I think the reason why is because Judge Simpson was being beyond accommodating to these parents. And my personal opinion is Judge Simpson was doing that because he realizes the ball got dropped somewhere along the way. And I could be wrong, but I think there was a pretty big turnover, change of things when Caitlin Kirby left and all that happened. And sometimes things slip through the cracks, and I think this is one of them, and that's tragic because 2 young girls lost their lives, and another went through hell, and now she has MS, which means the rest of her life is going to suck to some extent, because I'm sorry, there is nothing fun about MS, and even on your good days, something still sucks. Nothing is ever 100% again once you have it. Unless you have a super mild case. I mean, there's some people who might be okay, but everybody I know who has it, it's not fun. And by the way, the mother of the one child who survived and has MS, and the one that was driving and passed had a GoFundMe up. It's actually still open. I looked. There hasn't been any donations since the very beginning. There wasn't a lot of publicity on this case, and almost all the publicity was negative. It made it look like the girls were at fault. They were speeding, trying to get away from an accident. The media made it look like they hit him and then took off so that they wouldn't get caught, which obviously there's evidence to the contrary. They stopped, exchanged information, and then it seems like it's up in the air whether he was chasing them or not. So I'm going to put a link to the GoFundMe in the description if anybody's interested in looking at it. It's absolutely tragic, and the most he can get is 90 days at this point. Although, if he's withdrawing his plea, then we're going back to the original felony charges, I believe. I'm not sure how that will work, but let's rewatch the attorney meltdown. Just because we can.
County of Washtenaw. Now in session. Judge J. Cedric Simpson.
Judge J. Cedric Simpson preside.
Okay, it's been a long day. I don't know what happened. Don't even look at me. Just kind of lost me. All right. Let's see here. We're all on. All right. Court does call the case of the people of the state of Michigan versus John Torres.
Good afternoon, Your Honor. Patricia Reiser on behalf of the people.
Good afternoon, Judge Joshua Van Laan on behalf of Mr. Torres, who's present in your courtroom.
Can you state your name, sir?
John Torres.
All right. This is the date of the adjourned sentencing date. There was statements given by the mothers of the two young ladies to the court. They asked the court to look at additional information, which the 911, the recordings of the 911 were sent to the court. The court had reviewed them. Was there anything else from either side before the court goes into its decision? Anything from the people?
No, thank you, Your Honor.
Anything from the defense?
No, Judge, you've given us ample time. Thank you.
Let me just say that, and I guess there isn't an easy way for me to say this. And I guess, I don't know, I know the mothers gave their statements at the last hearing. I don't know, was there anything additional you wanted to tell the court? No, from neither, okay. There isn't an easy way for the court to say this, except for to say that, well, first of all, and I'll give everyone another opportunity to speak after I say what I'm going to say and what the court looks at, what the court has at least surmised. Defense's position is that certainly the defendant ought to be sentenced on the charge that he pled to. Much of that, frankly, I guess bears on the concept, or at least what has been said, that the defendant, Mr. Torres, was not in a position to see the accident. And that he was someplace else, which led to the plea. And again, it's not the court's province to get involved in what the particulars of the charge are, but to try to do its best to mete out a just sentence. Part of the reason also that the court had made a determination to at least hear the 911 tapes. I have a copy of the police report as well as Mr. Torres' statements. Was because I was going, and I said to the parents that there may not be anything that the court could do, but you were going to be heard by this court. And in doing that, some things, as I saw them, were a bit disturbing to me. And, you know, I'm not in, nor should I be in a position necessarily to do some investigation to try to figure out what transpired entirely. But ultimately the issue became, and I will make no bones about it, that if this court believed, despite the charges, that the defendant was indeed basically present when the vehicle went off the road and the accident occurred, that changes the court's perspective on what would be a proper sentence in this case. So initially, in listening to the 911 calls, particularly there were a few other calls, but I listened to Mr. Torres' call
to 911. And that initially caused me some concern about whether or not the defendant saw this accident. And here's why. And again, I will give an opportunity to respond, but Mr. Torres initially contacts 911, and what was said to the court by Mr. Torres and what he had maintained to probation is that he didn't see this accident. I'm having a very difficult time believing that. And let me explain my reasons why. Defense counsel, I think, properly stated before that that Mr. Torres had called from someplace else. Mr. Torres contacts 911, and it's an odd call because of the way that I think the dispatcher was responding to Mr. Torres. But one of the things that was said is Mr. Torres put himself at First Street off of Superior. The dispatcher says that's not where we have you. Put a pin in that because that becomes important in the court's mind. At some point, Mr. Torres then says, I'm at First Street. He is then headed back to the location of the initial contact between the vehicles. Okay. All of that being said, I then review the police report and Mr. Torres' statements. And if everyone can recall, one of the things that the court was looking at was, did Mr. Torres chase these individuals and cause this accident? One of the things that was said in counter to that is that he's not near the accident, doesn't see the accident. Again, I'm having a difficult time believing that. And part of the reason I'm having a difficult time believing that is because there is an EMU security camera that's referred to in the police report that has these vehicles traveling down Huron River Drive, both at a high rate of speed, because Mr. Torres is in an Equinox, I do believe, and there's a truck. At some point, they get to the corner of Huron River Drive in Superior. According to Mr. Torres, it is a red light. The truck stops. He stops at some point. The truck continues through the red light. Mr. Torres indicates from the report, at least as I read it, that he then turns on a green light. Now, how that certainly all could happen. Bottom line is that they're then, Mr. Torres indicates in the police report that at some point on Superior, he disengages from, as he puts, following the vehicle. It's best the court's able to determine the distance from that corner of Superior where the turn is made to the railroad tracks. It's approximately 1,000 feet. Mr. Torres is then, if he is correct, and he is saying where he is to the dispatcher, this is where we take the pen out of that he's at First, but the dispatcher is saying That's not where we have you. Mr. Torres is further up that road. But even if I give the defendant the benefit of the doubt that as far as he went was first, the railroad tracks are approximately 100 feet from that location. It is a clear shot from that location to see those railroad tracks and that intersection. It is not as though there is a crest. It is as though there is something that from first would obstruct one's view. The other thing that was specifically asked of Mr. Torres is he made it very clear that he did not go over the railroad tracks, but the additional thing that was asked is whether or not he crossed a bridge. Mr. Torres says he did not cross a bridge. That can't be true. Because as you're going up Superior, to get to First, you have to cross the bridge. Moreover, when Mr. Torres is later questioned and talking to the dispatcher, he had to not only cross that bridge once, he had to cross it twice because he had to go over the bridge and he had to come back to get to the location where it occurred.
Can I say something, Your Honor?
In a moment.
No.
No.
Moreover, when you listen to the other 911 calls that are called in, two vehicles that are traveling to the south, so they're traveling the opposite direction from the Getty's roundabout. They see the vehicle go in up, well, basically off the railroad tracks and have the accident. From really, and honestly, I mean, I don't know exactly where they are, but from putting again the defendant where he says he is, they are at a much further distance from those tracks than would be Mr. Torres. He's much further, let me preface this by saying, through the other hearings, it was stated to the court that he is nowhere near the tracks and that he is further from the tracks where this occurred. That can't be true and everything else be true. It just can't be. He is within 100 feet, really between 80 to 100 feet of that intersection when that vehicle goes off the road. Certainly, and it also is perplexing from the court standpoint. I thought I understood it initially. When Mr. Torres is telling the dispatcher that he has the license plate of the other vehicle, one is thinking, or at least I was thinking, that he is getting that license plate by following the vehicle. That's not the case. He actually had the license plate of the vehicle prior to it turning onto Superior. Hence, realistically, there is no reason whatsoever for him to have continued. There is no reason whatsoever for him to have continued up Superior behind that truck. Now, if somebody, and counsel, I will give you an opportunity to address the court on that. And like I said, I'm not here, and I explained to Mom, it's not my province regarding the charge. My province is to mete out the sentence with what's in front of me. And again, I will give an opportunity for a response, but I can tell you where the court is at this point. The court at this point is of the opinion, and that Mr. Torres saw this happen. When he talks about the kicking up of dust and other things, the only place in that area that's going to happen is basically at those tracks. It's not going to happen on the turn off of Huron River Drive onto Superior. You're not paid. And, you know, and I'll just say it, when I look at all of this, I'm having a hard time believing that he's telling me the truth about this. Ms. Weidling, can you just put that GPS up? That overhead.
Can I say something?
I'll let you, if your counsel believes that should speak, then I will let you speak, but
Are you ready?
I'm ready. Can you blow that up, or you're locked?
Do you need it closer?
Yeah, I just need it closer to the. That's good. Right. Yep, right there. At the very bottom of the screen, you're going to see the turn from Huron River Drive onto Superior. Up top of the screen, sir, you will not disrupt these proceedings. I do not want to kick you out, but you are not going to disrupt these proceedings. Up at the top of the screen, you'll see the railroad tracks. And if you look at, I think the first, if you look down from the railroad tracks off of Superior, that first street coming off, which would be as you're looking at the screen to the left, that's First Street. From there, you can see that there is a clear shot to that intersection with the railroad tracks. If Mr. Torres is there, he has a clear shot to that whole area. When you also look at it just in terms of his timing of the calls, the other calls that are coming in, he can't not be in that area and see what happens, because the other calls come in shortly thereafter, and they're traveling north from the Gettys area, traveling southbound on Superior. They see it. So again, I'm not here, I don't. I'm not here to worry about what's charged, what's not charged. I have to mete out the best sentence I can with what I have. And I will let you know, and counsel, I will give you an opportunity if you want to somehow or another speak with your client prior to the court imposing sentence. But I do believe that jail time is appropriate given what I see. I can't, in giving that, I can't bring back these young ladies. I told the parents, I can't do that. But I certainly can do the best that I can to make sure something occurs. If I believed that Mr. Torres was not present, that it was as it was portrayed to this court, a circumstance where he could not have seen it, that he would have been so far down on Superior that he wouldn't have seen the railroad tracks, then that's where I would land. And I would have no problem landing with that and justifying it. I can't, based upon his own statements, justify that as being true. He had to see it. He's telling me he's 2 to 3 cars behind them, that he's following them, and that he's at first, and it's a clear shot to those railroad tracks. If somebody wants to tell me how I can come to a different conclusion, then please tell me that. But I can take into account in terms of sentencing whether or not a defendant is being truthful with the court in terms of what they're saying. And I will be blunt. I'm just a plain talker. I don't believe that he is. Counsel, if prior to your, Mr. Torres is, I don't know that you can see him or not. He really wants to make a statement. I will arrange, counsel, I know you don't want him to. If you want, because since you're not here, if you want to talk to him, I will arrange to get him on a Zoom and get you guys into a breakout room so you can talk.
No, Judge, that's fine. I'm ready to make a comment when you're ready to hear it. I don't need.
Oh, go ahead. Sir.
Judge, with all due respect, this is wildly inappropriate. For you to be doing an investigation on your own, for you to be pulling up.
Counsel,
go ahead, Judge. You're the boss.
Counsel,
yes, Judge.
Stop a moment. I think I acknowledged that. I'm not here doing an investigation. The question is what was represented to this court is that he could not have seen it, that he was not following them. Anything that I have here is not an investigation. All I did was listen to the 911 and read the police report. So in that case, if you think that's inappropriate, then fine, you can go ahead with your statement. And then I will proceed to my sentence.
Right. In addition, Judge, you pulled up a map and you said that it's impossible to see, where the accident was without actually being at the scene viewing it. There was no trial. There was no any opportunity for the defense to present you with counter evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What do you want to give me? No, Judge, counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that will occur after this.
What you represented to this court, and I realize you're advocating for your client about him being someplace further from that scene, it's not true. It's his own statements. These are not anything where I went out there and I'm looking at something or I'm doing whatever. It's just placement. He's saying he's at first. I just listened to the tape. I didn't do anything. I didn't go out there and investigate, talk to any witnesses, do anything like that. I did that and looked at a map. That's all I did.
Right, Judge.
So if you want to give me something, counsel, you can come here 2 hours late. Give me what you want to give me.
Judge, I don't believe you should be considering anything after the fact of the initial accident. He's being sentenced for failure to stop at a PD accident. It has nothing to do with what he did afterwards. It's completely inappropriate for the court to be.
What he did afterwards?
After the accident, when he was initially rear-ended, that's what he pled to, failing to stop at that accident. It's not failing to stop at the accident that the girls were involved in. It's failure to stop at the accident where he was rear-ended. Ms. Reiser agrees.
If your client, knowing what I'm going to do, wishes to withdraw his plea, I will consider that motion.
Judge, I would also ask that you recuse yourself at this point.
Denied.
Understood. And I can, if you wouldn't mind allowing me to speak with Mr. Torres, my guess is he's going to withdraw his plea.
I'm sorry?
If you wouldn't mind allowing me to speak with Mr. Torres to make sure this is going to happen, but my guess is he will withdraw his plea.
Can we set up a breakout room for Mr. Torres in signing on to Zoom in one of the conference rooms? Mr. Torres, we're going to put you into one of the conference rooms out there. We're going to put that machine into a breakout room and put your counsel into a breakout room so you guys can talk. Court will stand in recess. All right. All right. 14A District Court is now back in session. The Honorable Judge Cedric J. All right, we're back on the record in the, is everybody here? Yes, they are. We're back on the record in the Torres matter. Had an opportunity, well, first of all, that counsel had an opportunity to speak with his client. Been also an opportunity for the court to speak with counsel. They are going to consider a motion to withdraw the plea or the other end alike. The court is going to give the opportunity for them to file the written motion to do so if necessary. I'm not saying that that's what they're going to do, but give that opportunity. So I'm going to adjourn these proceedings for the motion as well as sentencing. I'll set both at the same time to March, my next sentencing, March 13th. And I want a special time so that
3 p.m.
All right, March 13th at 3 p.m. for a continuation of the proceedings. I have directed counsel that everybody needs to be in person at that proceeding.
Understood.
All right, bond will continue. Thank you.
All right, thank you, Governor.
The next hearing in this case is scheduled for March 13th, I believe it is, in about a month. I have it on my calendar. I will stay on top of it, and I will bring you an update as soon as there is one. Thanks for sticking it out with me. Have a great day.